Representative Reed,
Yes.
Representative Sorolis,
Yes.
and Chairman Petrie.
Yes. Is that clear for consent? Yeah. All in favor of placing on consent?
Aye.
Any opposed? Will be placed on consent.
Thank you, Mr. Chairman, members of the committee.
Thank you. Up next for consideration is Representative Fisher or Representative Blanton here. I know, I'm waiting to go back and forth. We'll take a break for just a recess for just a moment. All right, we're back on, and we'll call 189, Representative Blanton. If you'll please state your names for the record and proceed.
Thank you, Mr. Chairman, members of the committee, for allowing us to be here today to present to you this important piece of legislation that will be beneficial to our probation and parole, but not only to them, but to our inmate population as well, as another tool in the toolbox for probation and parole to use to help get treatment for those that are in need. And I'll allow my honored guests to introduce themselves.
Good afternoon. I'm Melissa Chandler. I'm a member of the Kentucky Parole Board.
Good afternoon. Cindy Huddleston with the Legislative Services for Department of Corrections.
Mr. Chairman, with the introductions being made, as I briefly stated the importance of this, I'm going to turn it over to the experts in this field to explain this piece of legislation.
Thank you. Like I said, I'm Melissa Chandler from the Kentucky Parole Board, and we are asking for basically another option. When we see technical violators that come back before us, we want to have a continuation sanction to where we can get them the treatment that they need. We could give them up to 9 months to successfully complete this continuation sanction so they can get into substance abuse treatment, some other type of treatment, and then they would return back to the supervision out on the streets. This would apply to all types of supervision that we are the revoking authority for, so parole, post-incarceration supervision, sex offender conditional discharge, and MRS. Again, the Parole Board's top priority is public safety, and we would need to be able to look at and determine if this type of sanction would be appropriate for that offender, depending on what type of technical violation it would be. And then, again, keeping in mind public safety is number one. Once they do receive that important treatment, that they return back to supervision.
Mr. Chairman, I would make note to the committee that this piece of legislation passed this committee last year. It passed the House into the Senate, and for whatever reason it stalled there. The impact study does also show a potential that this will lower, this will be a cost-saving measure, could potentially be a cost-saving measure for the Department of Justice, and also could help to lower some of the overcrowding in our inmate populations in our local jails. So also, Mr. Chairman, if I may, on another note, with this committee, record a I'm present for the Secretary. Would be glad to take any questions.
All right, any questions on the bill? Seeing none, call for roll. No, I'm sorry. All right, thank you. Bear with me. Motion, we got a second? Roll call.
Representative Blanton,
Yes.
Representative Booker, Representative Bratcher, Representative Cantrell, Representative Elliott, Representative Fisher, Representative Harris,
Yes.
Representative Hatton, Representative Hoover, Representative Kulkarni, Representative Lee, Representative Lewis,
Yes.
Representative Maddox, Representative Massey, Representative McCoy,
Yes.
Representative Meeks, Representative Mentor,
Yes.
Representative Mosier,
Yes.
Representative Nemus,
Yes.
Representative Reed, Representative Sorolis, and Chairman Petrie.
Yes. All in favor? Any
Aye.
opposed? Be placed on consent.
Thank you, Mr. Chairman, members of the committee.
Thank you.
Thank you. And if y'all can bear with us for just a moment, we've got multiple committees going on with multiple bills being presented in each of those committees, and we're having to shuttle people back and forth, and we have no control over what happens in the other committees. So we're going to take a brief recess again until we get the next sponsor on. All right, we're back on, and we'll call up HB 201, please, Representative Fisher. (201). State your name and proceed, please.
Joe Fisher, State Representative, here to present on House Bill 201, which has to do with service of process on non-residents of the state of Kentucky. Kentucky's long-arm statute sets forth 9 standards to obtain jurisdiction over a non-resident defendant. The long-arm statute also lists 2 methods to obtain service of process on these out-of-state defendants. House Bill 201 would allow certain additional methods of service on out-of-state defendants by incorporating the service of process methods under the civil rules. No longer would Kentucky plaintiffs be required to either find and serve the non-resident while he happens to reside in Kentucky or to serve the Secretary of State. Both of those methods are more expensive and time-consuming than those available under the civil rules. This change in the service of process requirements will make litigation simpler and less expensive, at least in its early phases of litigation. This would put us on par with other states that allow service of process on out-of-state defendants by use of certified mail. Are there any questions?
Any questions? Representative McCoy.
So I was waiting on the light to come on. I guess I have to push it myself. Thanks. Thanks. Representative Fisher, this doesn't address or change the long-arm statute in any way, does it? This is just service of process.
It's as part of the long-arm statute, the service of process portion is Section 3A, and it just adds the civil rules methods of service.
But no change in jurisdictional sort of
They would still have to prove the necessary contacts with the state in order to obtain service.
Thank you.
Representative Harris.
Thank you, Mr. Chairman. Representative Fisher, living in a border county, we do a lot of service of process across state lines in my practice. Can you explain to me the exactly? You say that we can obtain service of process on non-residents in any manner authorized by the Kentucky Rules of Civil Procedure.
Mm-hmm.
So Kentucky rules allow you to serve in person. This wouldn't allow you to go across a state line and serve somebody in person, would it?
No, it would not. You would still have to, if you wanted to serve in person, you'd have to send it over to the other state or have somebody individual service the process over in another state. So, no, but this would allow certified mail across state.
Okay, so this will just kind of open that up and allow you to serve somebody by certified mail. Okay, thank you. Thank you, Mr. Chairman.
Representative Elliott.
Thank you, Mr. Chairman. Representative Fisher, is this done in any other state? Is this model of another state?
In my neck of the woods, it's very common for Ohio plaintiffs to serve Kentucky defendants by certified mail. And as long as that Kentucky defendant has had the necessary contacts with Ohio to obtain under their long-arm statute.
Okay, thank you.
Representative Nemes.
Thank you, Mr. Chairman. There was a case from Indiana or Kentucky a few years ago where an Indiana casino was sued, and this I think would resolve this matter. And the Indiana casino went all the way to the Kentucky Supreme Court. The Kentucky Supreme Court read the statute that currently exists and says even though you could sue them under the Constitution, the statute is more limited than the Constitution. So our Kentuckian wasn't able to bring that lawsuit. What this would do is it would allow Kentuckians to have the full extent of the United States Constitution's Due Process Clause and bring those types of cases. And so I don't have a question, but I wanted to mention that case, and that's, I think, the impetus for this needed change. Thank you, Mr. Chairman.
Representative Lee.
Thank you, Mr. Chairman. I just had a question or two about this, if I could. So this would allow you to serve an out-of-state defendant by certified mail. I mean, that's essentially what this bill does. Is that right?
It incorporates that civil rule which allows service by that method, yes.
Does it address at all who is authorized to sign on behalf of an out-of-state defendant?
If whatever the civil rules require proof of service shall be made either by return receipt mentioned in 401(1)A,
right,
or by affidavit of the person making such service.
What I'm getting at, and this doesn't change the existing law, which has been my experience, is interpreted differently by different judges in different counties as to who actually is authorized to sign a green card, because that's what you're looking for, is the return.
Right.
And this bill doesn't change that. Is that correct?
No, it makes it consistent with that civil rule, yes.
And if you don't get your green card back from your out-of-state defendant, does this change any remedy that might be available to a plaintiff under that circumstance?
It does not. You could go back to the Secretary of State and serve that way as well, so that is available.
And then at that point, you're looking at, I guess, constructive service at least.
At least, yeah, you would have to do whatever that civil rule requires, and whatever the common law rule requires for constructive service.
And this isn't affecting the type of judgment you could take against an out-of-state defendant who is before the court solely on constructive notice. Is that correct?
Does not change it.
Okay. Thank you, Mr. Chairman.
One brief question. This doesn't require non-residents to be served by certified mail, but it allows that. So it's a permissive, and you can still proceed with the Secretary of State as we have previously.
It's just an additional method, yes.
All right, thank you. Any other questions? I'll entertain a motion. Madam Secretary, call roll.
Representative Blanton, Representative Booker, Representative Bratcher, Representative Cantrell, Representative Elliott, Representative Fisher,
Yes.
Representative Harris,
Yes.
Representative Hatton, Representative Hoover, Representative Kulkarni, Representative Lee,
Yes, I'll vote.
Representative Lewis,
Yes.
Representative Maddox,
Yes.
Representative Massey, Representative McCoy,
Yes.
Representative Meeks,
Yes, ma'am. And Mr. Chairman, at the appropriate time, I'd like to place a result for the previous matter. Now, or you want me to wait?
Representative Minter,
Yes.
Representative Mosier,
Yes.
Representative Nemus,
Yes.
Representative Reed, Representative Sorolis, and Chairman Petrie.
Yes. Yeah.
Unanimous.
Mr. Chairman, may I record a vote?
Yes.
Sorry, it's next door. I vote yes.
Let's finish up on this one.
Unanimous to consent.
The motion on consent? All in favor? Any opposed? It'll be placed on consent. Representative Meeks?
Thank you, Chairman. I'd like to place an aye vote on House Bill 132, please.
Yes on 132?
Yes.
Thank you.
Thank you, Mr. Chairman.
Anyone else have any housekeeping about appearances or votes?
Mr. Chairman, yes, Mr. Chairman, I would like to record first of all, present,
Gotcha.
and secondly, a yea vote on 132, please.
Thank you. Yes on 132. Representative Massey?
I would also like to be counted now as present. I'm sorry I was at another committee meeting presenting, and also record a yea vote as well.
Which bill?
132.
Thank you.
Mr. Chairman, I would like to record a yea vote on 132 as well. Thank you.
Thank you. Any others? All hearts and minds clear. We're done here. We'll take up House Bill 148. Representative Fisher, if you'll remain there and proceed, state your name for the record, and proceed as a housekeeping matter. There is a committee sub in the folder.
I would move that the committee sub be adopted.
All in favor? Take a roll call. It's adopted. And if you'll proceed, please. Sorry? All in favor?
Aye.
All opposed? No. It's adopted. Proceed.
Thank you, Mr. Chairman. Joe Fisher, State Representative. I'm here with Representative Tate, my primary co-sponsor on House Bill 148. House Bill 148 is Kentucky's version of the Human Life Protection Act. Similar laws have been adopted in 4 other states, North Dakota, South Dakota, Mississippi, and Louisiana. Arkansas's version recently passed the Arkansas Senate and is pending before its House. I also understand that today the same bill has been introduced in Tennessee. Kentucky's bill most closely resembles the Louisiana law. House Bill 148 will provide full legal protection to every unborn child in Kentucky from the moment of fertilization to childbirth, only if the Supreme Court reverses Roe v. Wade or the Constitution is amended to restore authority to every state, to any state, to prohibit abortion. House Bill 148 would essentially restore the right to life in Kentucky as it existed before January 22nd, 1973. I will quickly go over the key provisions of the bill so that there is no confusion about what the bill does and doesn't do. Subsection 3A of the bill sets forth the criminal intent standard for the crime of abortion. It says, no person may knowingly either prescribe a drug or use an instrument with the specific intent of causing an abortion. In addition to the special criminal intent standards, subsections 4, 5, and 6 of the bill provide specific exemptions from prosecution. Under 4A, there is no violation if the abortion is necessary to save the life of the mother. Under 4B, there is no violation if the medical treatment of the mother results in the unintentional injury or death to the unborn child. Remember, there must be specific intent to kill the child. Subsection 5, there is no criminal liability placed on the mother for consenting to the abortion. Subsection 6, there would be no violation for prescribing the morning after pill, since that would be taken before there is knowledge of the pregnancy. There has been some discussion about House Bill 148. A couple items I want to address before perhaps the opponents come and testify. One of the questions was whether the delayed implementation, the trigger clause of this bill, when Roe v. Wade is overturned, violates Section 60 of the Kentucky Constitution. Section 60 states, no law, with a few listed exceptions, shall be enacted to take effect upon the approval of any other authority than the General Assembly, unless otherwise expressly provided in the Constitution. The effective date of House Bill 148 does not depend upon the bill's specific approval by the Supreme Court or any other agency of government. House Bill 148 will take effect only if the Supreme Court reverses itself on a specific case. It does not require approval of this bill, so this bill does not violate Section 60 of the state constitution. The other objection will be that Roe v. Wade is settled law, that this bill is divisive and premature. Why not just wait until Roe v. Wade is overturned? My answer to that is Roe v. Wade is now 46 years old and is still the least settled and accepted opinion since Plessy versus Ferguson was decided in 1896 and not overturned until 58 years later in 1954 under Brown versus Board of Education. We recognize that the Chief Justice Roberts has a certain fondness for judicial precedent, but that precedent has created such ongoing division among the states, like the Dred Scott decision did in 1845 and led to a civil war. The Supreme Court will, if asked, be willing to reverse itself and allow the states to regulate abortion as they deem appropriate and had occurred before 1973. Already we're seeing various states, which are the laboratories of democracy, enacting laws dealing with abortion in anticipation of the repeal of Roe v. Wade. We're seeing states like Arkansas, Kentucky, and Tennessee choosing to protect life from the moment of conception. On the other hand, we're seeing New York, Virginia, Rhode Island, and New Mexico extending abortion rights to the third trimester and even beyond birth. Abortion is not a divisive issue in this Commonwealth. The people of Kentucky are overwhelmingly against abortion. House Bill 148 will serve as a message from the people of Kentucky to the United States Supreme Court and all the rest of the states. The message is this: if you restore our authority, we will protect every unborn child in this Commonwealth. Before we yield the floor here, I want to talk a little bit about the history of abortion legislation in Kentucky. The earliest abortion statute in Kentucky was enacted in 1910, but even before that date, abortion was banned and punished under the common criminal law of Kentucky. Under the common law, abortion was banned after quickening, which is about 13 weeks, largely because the baby's movement in the womb was the first confirmation of the pregnancy. At that point, it was felt that a physician should not be punished for performing an abortion when no one confirmed that the fetus was alive until after quickening. By the late 1890s and early 20th century, biologists began to recognize certain chemical secretions in the body that they called hormones. In 1903, Dr. Frankel identified hormones that had a role in female reproduction, including progesterone that promoted gestation and development of the unborn child. So in light of this scientific knowledge, the Kentucky General Assembly, on March 22, 1910, enacted the first statute defining the crime of abortion and prescribing the penalties. Abortion included the use of any drug or instrument with the specific intent, same as this current statute, to procure an abortion at any time during gestation, whether before or after quickening. And if the abortion was successful, the abortion provider could be sentenced from 2 to 21 years in prison. The 1910 law was recodified in 1942 with no substantial changes and remained in force until the General Assembly repealed the law in 1974 during the first general session after Roe v. Wade was handed down. So Kentucky has a long and storied history of protecting human life at all stages of development, at least until the Supreme Court removed that authority and invalidated that statute. If there are any questions, I'm willing to entertain them.
I have two representatives that I asked some questions, Cantrell and Lee, and we have some people that have signed up to speak. Do you want your questions to the sponsor or in general? Can we wait for the other presenters? Sponsor?
My question is for the sponsor, but I'm willing to do at what the chair decides.
Representative Cantrell, proceed.
Thank you. And thank you, Mr. Chair, and thank you, Representative Fisher. I do have a couple of questions, and my questions are primarily relating to Subsection 2, which is, as you said, the triggering clause. My first question is, because it says reverses in whole or in part, there are a lot of different ways that a Supreme Court case can be decided, and I'd like to hear your intent behind the language in whole or in part.
My intent is that if the court reverses Roe v. Wade in whole or in part to allow states to regulate abortion again, that would be my intent. And I don't think this bill would take effect, or it could take effect, if they didn't repeal or reverse that part of their decision.
Do you think that specific language to you would have to be in there in order for this bill to take effect?
If they invalidated the whole, no, it would not. Is it in there? Yeah, it's limited to thereby restoring whatever the effect of the decision is in whole or in part. It must restore to the Commonwealth of Kentucky the authority to prohibit abortion.
And may I ask another question, Mr. Chair? Thank you. This seems to me to be a very subjective determination of whether a Supreme Court case, some cases do explicitly overturn precedent, and sometimes they don't. Sometimes they might hint in what, you know, and you and I, Representative Fisher, attorney, sometimes they hint in dicta that they might be either willing to go down that route in a separate case, and maybe the facts just aren't right, or maybe they're partially overturning. And to me, there seems to be no oversight here, because no one's going to look back at this. For example, I think an appropriate person would be our Attorney General, and I'm not saying that because of anyone who's in office. I'm saying that we have an election this year, and our current Attorney General is not going to be Attorney General anymore. I'm saying that because that might be inappropriate as our chief legal officer in the state to take a look at the opinion to see whether this law, whether indeed, if a Supreme Court decides to overturn Roe versus Wade, whether indeed it actually did before this law goes into effect, sort of like a stopgap and someone to take a look. What do you think about that?
Well, I think hopefully we'll get some clarity from the Supreme Court, whatever they decide, whenever they decide to do that. It's the court's duty to be clear in its orders and in its opinions. If it's unclear, then certainly you're going to have litigation about this language, and probably and the other states that have adopted this as well. So, I put the burden of this bill is on the Supreme Court. I mean, if they don't give us language, opinion that restores the authority of the states to prohibit abortion, then it's not going to happen. It will have to be clear.
Do you see how there could be a little gray area?
There's always going to be gray area in court opinions. You can interpret court opinions any way you want.
That's what my concern is. But
And
that is all of my questions. Thank you, Mr. Chair.
Representative Lee.
Thank you, Mr. Chairman. I had a comment and then a couple of questions for the sponsors, if I could. First, with respect to Roe versus Wade, I think I could say this without fear of contradiction, that is probably the most reviewed and dissected Supreme Court opinion, certainly in my lifetime, and not my guess in anybody's. I don't think it's going to be hard to know at all if Roe v. Wade gets overturned. I think it'll be like seeing headlights on a road in the middle of the night. We'll know. But to the concern that maybe it's equivocal, the bill itself handles that, and the opinion has to restore Kentucky's rights. And that gets to my first question, Mr. Chairman. As I understand the law and the history of this, before Roe versus Wade, the issue of regulating this type of conduct was, in fact, a states' rights issue. It was left to each state. Is that accurate, Representative Fisher?
Yes, it was. Virtually every state had a statute regulating abortion in some way, other than New York at that time did allow abortions before 1973. But yes, each state had that authority, and it was understood that way. They had the authority under the common law way before in the 1870s to regulate abortion. So this Roe v. Wade was a transformative bill. It removes states' rights to do what they were doing for hundreds of years, and that's regulate abortions.
And if I could, Mr. Chairman, ask another question.
Proceed.
Thank you, Mr. Chairman. Representative Fish and Representative Tate, I wanted to ask you a question or two about the effect of the bill and when it would come into law. Is my understanding that the triggering clause, the mechanism of this bill will not essentially have legal effect unless and until Roe versus Wade is overruled in whole or in part. And if that's the case, my question is that under that circumstance, should the law take effect, Roe versus Wade has been overturned, conduct that has just been legalized in the state of New York with respect to abortions, that was celebrated by the governor of New York, that was celebrated by the legislature of New York, that was advertised with certain lighting of certain buildings in New York City, glorifying that kind of conduct, the conduct that would allow a baby to be born and then be allowed to expire and or be terminated. Would that kind of conduct then be legal under Kentucky law if this bill takes effect?
No, we are. This bill would do the exact opposite of what New York, Virginia, and Rhode Island and New Mexico are either proposing or have enacted. We're pushing the football the other way. We're saying from the moment of conception, that child will be protected. They're saying even after they're born, that child may not be protected. Now, the arguments you might make in New York would be that they're pressed the envelope too far, and that born child is now a person under the Fifth and 14th Amendment and may be entitled to federal protection under the U.S. Constitution. So you're seeing states push both ways, push the envelope both ways, but this bill will reflect what I think are Kentucky values and will protect all human life from the moment of conception.
And I appreciate that response, and what I'm getting and what I believe is going to evolve, if I can use that term, is that when Roe versus Wade is overturned, that there literally are going to be venues or cities or states and counties and so on that will allow that kind of conduct, that kind of procedure. And then there are going to be other states that are going to place quite frankly, a greater value on life.
There's speculation about that, what will happen when Roe v. Wade is overturned. I suspect that there'll be maybe 10 states that allow abortion up to the moment of birth. There'll probably be 10 states that don't allow it from the moment of conception. There'll probably be another 30 states that have some sort of trimester type of arrangement for the abortion laws. So it will be regulated in some way in most states, I believe. But I think there's probably only 10 or a dozen states that will do what we're proposing to do here.
And one final question, Mr. Chairman, if I could. Absent the United States Supreme Court decision in Roe versus Wade, that was the first federal overreach into that issue. Is that true?
To the abortion issue.
To the abortion issue.
Yeah. There were similar based decisions on contraception at that point. But let me just read you the statute that was in effect at the time Roe v. Wade invalidated our statute. It was any person who prescribes or administers or uses any instrument with intent to procure the abortion of that woman, unless the abortion is necessary to preserve her life. This has always been part of our law. Shall be fined not less than $500 nor more than $1,000, and confined in the penitentiary for not less than 1 year and not more than 10 years. So that's what the state of the law was. This bill will basically revert that back to the 1973 status. of the law on abortion in Kentucky, and we would go forward.
Thank you, Mr. Chairman.
Thank you. Representative Minter.
Thank you. I have a couple of questions for Representative Fisher, please. Representative, are you aware of any case before the Supreme Court during this term, that could possibly overturn Roe versus Wade in this term, not in the circuit pipeline?
I'm not aware. I understand they did refuse a Louisiana case that might have had some impact with respect to clinic regulations. I believe that was part of it. So but out there in the circuits, there are many cases percolating that might eventually wind their way up to the Supreme Court.
But since you admit that there is not a case being heard this term in the Supreme Court and that they did refuse to hear the Louisiana case, my question then is, so why do we need to do this now in this session, per your own admission, that we have no idea when and if the Supreme Court takes up a case that could reverse? We don't know what that decision would look like. We don't know if it would reverse in full, in part, not at all. So why do we need to do this now?
Well, I want to be on the standby list. You know, when you go to the airport and you get there early and you see on the chart a flight that might leave earlier and get you to your destination, you get on the standby list and try to take that flight to your destination as quickly as possible. That's the intent of this. Once Roe v. Wade is overturned, Kentucky law will, at that point, automatically protect all human life from the moment of conception onward. That's my destination. That's always been my destination in my pro-life work, and this bill would achieve that.
Representative Blanton.
Thank you, Mr. Chairman. A couple questions for Representative Fisher. First of all, thank you, Representative Fisher, for this good, solid piece of legislation that you brought forth. And I consider you to be very astute in KRS. So in Kentucky, if someone's involved in an automobile accident, and let's say they're under the influence, and a lady is in their vehicle or another vehicle in that collision, and they are pregnant, and that child within that womb dies because of the injuries of that accident, is there not a criminal charge for that in Kentucky?
There can be if it's not an accident. It has to have some intent, some recklessness associated with it, and I'll refer you to Representative Lee, because that was his bill back in 2004 that created that crime in Kentucky.
Mr. Chairman, follow up. So with that, there is an intentional act when abortion occurs. What's the difference in that fetus or that baby and a mother that's there to get an abortion than there are in that automobile?
There is no difference. There is a disconnect there between the laws. One recognizes that unborn child as a person to receive protection from that sort of incident, whereas an abortion, because of Roe v. Wade, we're not able to extend that protection.
Thank you, Mr. Fisher.
All right. Representative Solares.
Representative Fisher, as I read your bill, there's no provision to allow termination of a pregnancy in the event of a death in utero, non-viability. So it's your intent to make a woman carry a fetus to term even though the child is already dead?
Well, there has to be intent.
No, it has to be intent to have an abortion as I read it.
Well, an abortion itself is an intentional act. If the child is already dead, there is no intent to kill that child. So that dead child could be delivered without any legal liability.
I don't think the bill is clear on that point, sir.
Mm-hmm. Yeah.
Any further questions?
No matter what under the circumstances.
Representative Solaris, any further question?
No, Chairman.
Thank you. Representative Nemus.
Thank you, Mr. Chairman. I would refer my friend from Jefferson 48 to Section 1, Sub 1, B, where it says living unborn human being. Thank you, Mr. Chairman.
Any further questions at this time for the sponsor? We have the persons signed up to speak on the bill. And I apologize in advance for mispronunciations of names, but there's a Dr. Kenneth Zagart, Tamara Weeder, Annie Prestrud, Reverend Derek Penwell, and Kate Miller. And I have had some indication that the 5 of you may want to come to the table at one time. Is that correct? That'd be great. Thank you. And if someone will take lead and start the introductions, and everybody state their name for the record, please.
Thank you. My name is Kate Miller. I'm the Advocacy Director for the ACLU of Kentucky, and I'm here to testify against House Bill 148. Thank you, Chairman Petrie, and members of the Judiciary Committee. As you all know, this is a bill that would prohibit almost all abortions without any regard for the particular circumstances of an individual's life. Decisions about pregnancy are personal, and they can be complicated, and they're best left up to the pregnant person. Circumstances surrounding a pregnancy can be complex, and I'm going to provide just a few examples of what some Kentuckians are experiencing when it comes to making decisions about pregnancy. According to a recent report, about 2/3 of women in Kentucky that obtain an abortion already have at least one child at home. Many of these women are single parents, and many are low income or are living in poverty. As you know, of course, Kentucky is the 4th poorest state in the nation. Kentucky women are much more likely than Kentucky men to be living in poverty. And this is partly because women are more likely to have dependents that they're caring for. Single mothers in Kentucky are much more likely to be living in what's called deep poverty, meaning that they live at 50% of the poverty level or below. Poor women are less likely to have health care and are disproportionately more likely to access abortion. Research also shows that low-income women and women living in poverty experience high rates of domestic violence. And domestic violence results in higher rates of unintended pregnancy for a number of reasons, including birth control, sabotage, coercion, and sexual assault. Pregnancy, unfortunately, puts women already living in an abusive relationship at a higher risk, an even higher risk of experiencing violence while they're pregnant. And so, not surprisingly, policies like these that restrict access to abortion put women at greater risk for experiencing violence in their home. Pregnancy is not just dangerous for those experiencing intimate partner violence. The United States, as you all probably already know, has the highest rate of maternal mortality in the developed world. And black women die at twice the rate that white women do. That's true across the country and here in Kentucky specifically. And we don't do a very good job of tracking those deaths either. The bill you're voting on today offers few exceptions for the health of the mother. It's very limited, and absolutely no exceptions for fetal anomalies. If at any point in a pregnancy a fetus becomes incompatible with life, so maybe they continue to have a heartbeat, but it's a non-viable, serious condition that's diagnosed, a woman, regardless of how far they are in their pregnancy or how early they are in their pregnancy, will be forced to continue to carry that pregnancy. New York's law specifically addressed fetal anomalies and the health needs of the mom. There's an excellent explainer in the Jesuit magazine America that I would encourage folks to look at. This law offers few exceptions for the life of the mother, no exceptions for fetal anomalies, no exceptions for any kind of rape, including incest, no exceptions for individuals who are survivors of domestic violence. And from our perspective, it tries to take something that can be incredibly complicated, the lived experiences of pregnant people, and make it very simple. But I think most of us believe, when it comes to our friends and family and people that we know who are pregnant, most of us, I think, believe that it isn't always simple, and that decisions about pregnancy should be up to the person who's pregnant, not to the government, particularly a government that's dominated by men, that was certainly more heavily dominated by men in 1973 and 1910 and in the 1800s. And so I ask you to encourage leaving these types of decisions, particularly difficult ones, up to the women that are pregnant.
Hello, my name is Tamara Weeder. I'm the Public Affairs and Policy Director for Planned Parenthood Advocates of Indiana and Kentucky. I am here today in opposition to House Bill 148. The explicit goal of this bill is to immediately ban all abortion care in the state if Roe v. Wade is overturned. This is an extreme bill that risks Kentuckians' lives for political gain. If allowed to take effect, the consequences would be dire. House Bill 148 simply goes too far in inserting government into our personal, private lives. This bill affects important life decisions that should be made by individuals in consultation with their doctors, their families, and their faith, not extremist politicians. According to the American Congress of Obstetricians and Gynecologists, decreasing women's access to abortion will likely increase negative health outcomes and complications, including maternal and infant mortality. Nearly 3/4 of Americans, 72%, do not want to see Roe v. Wade overturned. This includes a majority of Democrats, of independents, and Republicans. Americans are much more united on this issue than the divisive rhetoric would make seem. It is critical that abortion remain a safe and legal medical procedure. In Ireland, for example, which up until recently banned all abortion, Dr. Savita Hoppenvar experienced a tragic miscarriage at 17 weeks. And even when it was clear that the pregnancy was lost, she was denied a necessary abortion for days. As a direct consequence, she developed sepsis and died. Doctors were unable to provide basic care for her because they didn't understand the law and they were confused on how and what they could do. If Kentucky bans abortion as a result of this bill, the same thing can and will happen here to Kentucky women. We know this because thousands of women lost their lives to unsafe abortions before Roe. Kentuckians were having abortions in the United States long before the Supreme Court legalized the practice in Roe v. Wade. The difference is that before Roe, in states that banned the procedure, women were receiving illegal, oftentimes unsafe abortions that could put their health, their lives, and families in jeopardy. There is a range of estimates on how many illegal abortions occurred in the United States before Roe, ranging from 200,000 to 1.2 million per year in the 1950s and 60s. Legal abortion is one of the safest medical procedures in the United States. The truth is that outlawing abortion would put pregnant people's lives and health at risk. The impact of abortion restrictions is predominantly felt by those who already experience barriers to health care, including young people, women of color, and those with disabilities, people with low incomes, and those who live in rural areas or are undocumented. Banning abortion altogether could place these lives in jeopardy. Compare this to when communities do have access to abortion care and we see health outcomes and economic security improve. People living in states with policies that support access to reproductive health care have higher earnings and are more integrated into the workforce than other states. The truth is that access to abortion is a core component of social and economic equality and is crucial for individual liberty, dignity, equality, and privacy. This is why I urge you to vote no on House Bill 148.
Mr. Chairman, members of the committee, my name is Kenny Ziegert. I'm a board-certified retired obstetrician and gynecologist who grew up in Louisville and practiced medicine in Louisville beginning in 1968. I want to put a clinical face on the whole idea of abortion. I started in practice, as I said, in 1968, 5 years before Roe v. Wade. I've been in the front lines. During my training, I witnessed several women coming in the ER bleeding profusely, having attempted abortion by using catheters, coat hangers, whatever method was used at the time. These women were ill, they were septic, and yes, some of them died needlessly because of the laws at that time. Therefore, I am vigorously opposed. It takes away a Kentuckian's ability to make a personal and private decision about termination of pregnancy. That said, what I'm really asking is to augment what the representative over here said before about a fetus already died, to have some limitations regarding exceptions to this House Bill 148. I want to add, other than fatal fetal anomalies should also be excluded in this bill, and along with my colleague, I think rape and incest should also be an exclusion in this. Keep in mind that a woman bearing a child always faces a potential threat of death. Pregnant women are entitled to the same rights of privacy, autonomy, and opportunity as non-pregnant females. And I thank you for your listening to my testimony.
Good afternoon. My name is Annie Prestrud, and I live in Louisville. In January 1998, when I was 24, I became pregnant. I had a very regular cycle. I missed one period, took a test right away. There was no delay, but I was already 7 weeks pregnant. I'd recently graduated from college with a bachelor's degree in psychology. I had a job with no benefits that would end in a year. I was living month to month. I had no emergency fund. I certainly wasn't making enough money to support two people, and the future with my boyfriend was uncertain. So I made a choice, and I scheduled an appointment at Planned Parenthood for an abortion. I had limited support. My family didn't live locally, and though my boyfriend accompanied me to the clinic, he wouldn't take time off from work to be with me the next day. I had to pay for the abortion with a credit card. I didn't tell my roommate Jill, and I didn't tell my mom, who's here with me today, or my sister, because I didn't want to share this news over the phone. What I didn't know then is that almost half of pregnancies are unintended, and that by the age of 45, 1 in 4 women has had an abortion. So now I'm making a different choice, making the choice to share my experience so that other people will know they're not alone. Having an abortion enabled me to move forward with my career. A year later, I started an exciting job in research, and in 2003, I completed a master's in public health. I've been a health services researcher for over 20 years, and I've contributed significantly to the care of patients with cancer. But perhaps more importantly, I'm a reproductive justice advocate. I serve on the board for the Kentucky Religious Coalition for Reproductive Choice. I'm the co-chair for their Legislative Advocacy Committee. I also volunteer for the hotline for the Kentucky Health Justice Network, and I'm here today. I've been fighting for the right to access reproductive health care, safe, legal abortion, since I was 16, and I will continue to fight. I will be here tomorrow, and I'll be here the next day. On the hotline, I have the opportunity to talk with people who are seeking abortions, just as I once did. 60% of people seeking terminations are already parents. Time and time again, I hear the same thing. These folks are trying to do what's right for them and their unique circumstance. Since the Roe decision, an onslaught of legislation has been produced to limit access to reproductive health care. Such legislation has attacked the right to safe, legal abortion, as well as limiting sex education curricula and access to birth control. It's worth noting that these legislative bodies have largely been comprised of men, white men, much like this body. These continued attacks on people's fundamental rights to control their bodies is an attack on the bedrock American principle that all are created equal. House Bill 148 will not stop abortions from occurring, nor will overturning Roe versus Wade. Abortion has existed since the dawn of humankind, and it will continue to exist. Laws to limit abortion access will unnecessarily increase risks to patients who already have an absence of options to prevent pregnancy in the first place. Let me be clear. No matter what law you pass, you will not prevent abortions from happening. But you, each legislator who votes for these laws, will increase the risk to people who choose to have an abortion. I urge the members of this committee to consider the rights of people who can become pregnant. I respect that there are divergent views about abortion, but your belief system, and your belief system should not impact my right to self-determination. Kentuckians should have the right to determine when and if they become a parent. Thank you, Mr. Chairperson.
Thank you, Mr. Chairman. My name is Derek Penwell. I'm the senior pastor at Douglas Boulevard Christian Church in Louisville, and I rise today in opposition to House Bill 148. This bill, as a function of its stated intent, would effectively outlaw women's access to safe and legal abortion, as has already been said. And what we know from history is that such a prohibition would not end end abortion. It would only make those attempts to seek abortion much more dangerous. As a pastor, I'm concerned about the continued encroachment of government on private health care decisions, which are better left to a woman and her physician. For people of faith, the issue of justice should motivate our politics. And sadly, this bill threatens justice for women who would have to live their lives with the outcome of a decision made by politicians who are far removed from the situation. According to the health services director at the University of Louisville, where I'm also a lecturer, the number one reason women drop out of college is unintended pregnancy. As a pastor, I cannot in good conscience support any legislation that would seek to prevent a woman and her physician from making the best health choices for that situation. Moreover, the injustice of forcing decisions on women and their bodies abrogates the right to dignity and the ability to flourish that God intends, foreclosing in many cases a woman's chance at a future over which she, and not her political representatives, has control. Consequently, I urge you to oppose this bill. Thank you.
Representative Lee.
Thank you, Mr. Chairman. I had a couple of comments, if I could, and then I had a question for one or more of the panelists. First, with respect to the issue of race that was brought up. There is nothing discriminatory about this piece of legislation. The lives that would be saved would be of all races. So there's nothing racial or discriminatory about this legislation, but I was glad that one of the panelists brought up the fact that we're all created equal, and that, Mr. Chairman, as you know, comes from our Declaration of Independence, and what it says is that we hold these truths to be self-evident, that all men are created equal, and I agree with that, and I bet everybody in this room agrees with that. And it says that they are endowed by their Creator with certain unalienable rights. And Mr. Chairman, ladies and gentlemen, members of the committee, do you know what the first right listed is? It's the right to life. Now, I appreciate the passion that these panelists have brought to the table. I understand that. And what I would hope for and ask for is the same type of consideration for those of us who have passion for that little unborn life. Because there's times doesn't seem to be anybody looking out for that little life. And now we know that little unborn life in New York can become a born life and still be at risk. And I find that abhorrent. I find that against anything civilized in any society. So I think that's a sad state of affairs. And then the ladies' health, and nobody on this panel, nobody who supports this legislation, Mr. Chairman, wants any woman to suffer ill health effects or anything like that. But the statement was made by one of the panelists that the consequences of this legislation would be dire. Well, I would submit to you, ladies and gentlemen, that the consequences of not passing this are clearly dire to that little unborn child. What chance does that child have? What say does that child have? Then I heard another statement that allowing safe legal abortions results in higher earnings. Higher earnings. Well, I can tell you one thing it doesn't do. It surely doesn't result in any higher earnings for any of these unborn children, does it? They don't even get a chance. And we heard some discussion, Mr. Chairman, about poverty. And yeah, we've got poverty, and nobody wants anyone to be in poverty. There's not a member of this committee that wants any citizen out there to be in poverty. But I will tell you this, that at least if a citizen is living in poverty, they're living. That little child's not given an opportunity to live otherwise. And then we heard a comment from our friends over at the ACLU that, and maybe I heard it wrong, and perhaps she'll favor me with a correction. But if this bill passed, I thought I heard, Mr. Chairman, that if this bill passed and became law, that there would be an increase, that women would be at a risk of an increase of domestic violence. And I don't follow the logic, and perhaps it can be explained to me, Mr. Chairman. So, Ms. Miller, can you explain to me, maybe I took your testimony down wrong, but is that true? Do you really believe that?
What we've seen from a number of examples in research is that women who are in abusive relationships experience a higher rate of violence when they are pregnant, and that women in abusive relationships are often essentially forced or tricked into pregnancy through what's called birth control sabotage, which might not be a term you're familiar with, but I think it's pretty self-explanatory of how someone could prevent someone from actually accessing their birth control or replacing their birth control. We know that through sexual violence, rape, and assault, individuals don't have control over their bodies, and subsequently an individual can become pregnant even without having the autonomy to consent. And so when an individual, for example, who is a victim or survivor of domestic violence is forced into an unintended pregnancy and then forced to carry that pregnancy, it can put their lives in further danger based on the research that we've seen around increased rates of violence when an individual is pregnant. Is that helpful?
Well, I don't know what studies or research you're citing, but
I'd be happy to provide you with
the logic
the citations
that you're attempting to employ. I don't think holds water. Passing this legislation, if this becomes law, to suggest that it's going to subject ladies to domestic violence, I find that hard to believe. But I understand people can get studies and make them say a lot of things. I understand that's how a lot of this works, Mr. Chairman. So I appreciate you giving me the opportunity to question.
If you don't mind, get studies to me.
Absolutely. Thank you, Chairman.
I'm sorry. Second. As amended.
Yes.
Representative Namus. We're ready to vote. We got a motion and a second. You good? All right, motion and a second to approve HB 148 as amended. House Committee Sub 1. Madam Secretary, please call the roll.
Representative Blanton,
Absolutely, unequivocally, yes.
Representative Booker, Representative Bratcher,
Yes.
Representative Cantrell,
May I explain my vote, please, Mr. Chair?
Briefly.
I'm casting and explaining a no vote today, and the sponsor and proponent of this bill said that people like me who oppose this bill might find it to be premature, and I'd already actually had that word written in my notes. I find it's premature for a different reason than what the sponsor of the bill said, and it's not necessarily because Roe versus Wade is well-settled law, which I actually do believe that it is, but it's actually because there's so many more unanswered questions about this legislation. The proponents of this bill seem to have already written the decision. They're saying when Roe versus Wade is overturned, and I wish I was as confident in that as they seem to be, but this is not a foregone conclusion. I very much believe in being an attorney, reading Supreme Court decisions. That is not always a clear-cut answer and may not give states the direction that it needs to enable a bill like this. There's a lot of speculation even about what the justices might be thinking right now, especially Justice Roberts in citing against hearing that case from Louisiana. So there are just so many unanswered questions, and this bill could lead to a very subjective determination without anybody giving any oversight or guidance about when this legislation could take effect. And for those reasons, Mr. Chair, I do believe that we've heard testimony that we do not need to. There are not any cases in the pipeline in the Supreme Court right now. That this legislation is very, very premature, and I will be voting no.
Representative Elliott? Aye. Representative Fisher?
Yes.
Representative Harris? Yes. Representative Hatton? Yes. Representative Hoover? Representative Kulkarni?
Yes.
I will be voting no on this bill today, primarily because what it does essentially, and as confirmed by the testimony of Representative Fisher, all it does is sets us back 50 years. It restricts the autonomy of a woman to be able to determine her life course. And more importantly, it's a knee-jerk reaction to a situation that is entirely hypothetical. Nobody sitting in this room, including the sponsors, have any idea what a partial or full repeal of Roe would look like. This is not a policy that is based in reality. It's not based on any tangible policy purpose. And I think the people of Kentucky deserve better than a knee-jerk reaction that is based on a situation that has not happened.
Representative Lee?
Yes.
Representative Lewis?
Absolutely, yes.
Representative Maddox?
Mr. Chairman, may I explain my yes vote, please? Yes, I have heard from more than one panelist here today in testimony that there is an overrepresentation of men in government, and as a mother, as a state representative, and as a woman, I vote yes.
Representative Massey?
Yes, ma'am.
Representative McCoy?
Yes.
Representative Meeks?
Absolutely not.
Representative Minter?
I'd like to swing my vote, please.
Yes, Bree.
Trigger laws are legal anomalies that are unparalleled in any other area of constitutional law, and they seem to only be used when reproductive rights are involved. And the people don't send us to Frankfurt to pass laws on things that may or may not happen, and I don't think we should be in the business of legislating to something that may or may not happen. This is actually bypassing democracy, because when and if Roe is overturned, then those who want to end legal abortion or those who want to continue legal abortion expect their representatives to have a meaningful and complex conversation about this that would take into consideration current public opinion at that time. This subverts democracy, a point on which I wish everyone on both sides of the issue could agree. I vote emphatically no.
Representative Mosier?
Yes.
Representative Nemes?
Yes.
Representative Reed?
Yes.
Representative Sorolis?
Yes, Bree.
I don't think that our representatives are sent here to engage in hypotheticals, and that's all this is. There's a broad spectrum on which Roe could be modified or not, and we won't know what that is until the Supreme Court decides to rule. In addition, I am not in favor of any bill that doesn't define what substantial risk is, doesn't define if that includes mental capacity, health issues alone, and would subject a mother perhaps to a late-term abortion because the substantial risk doesn't occur until the end of a pregnancy. In addition, I am not willing to subject 14-year-old girls to carrying a pregnancy caused by rape or incest to term. I believe our women deserve better than that. Finally, we don't address enough of the possible outcomes of a pregnancy that's troubled, and the grandstanding that this type of legislation creates is just not beneficial to the Commonwealth. I vote no.
And Chairman Petrie.
Yes. Very good. All right, having received 15 ayes, H.R. 148 as amended is reported with favorable expression. The same should pass. Entertain a motion to adjourn. Second.
Mr. Chairman.
All in favor?
Mr. Chairman.
Did I? Hold on a second.